Julie, I'm a lawyer, not a psychologist, but I don't know what's in the book. I don't know what the book represented. I guess prosecutors would be, from a prosecutorial standpoint, trying to see if there was some sort of theme in that book that may give some explanation as to motive. But I really don't find this to be a huge piece of evidence. The motive is very clear here. It's written out by him specifically. We don't have to find it in a book or another piece of evidence. And what to me is more relevant is the gun range, because the gun range actually, if I may amplify the answer that was just given, goes strategically to the most important part of the prosecutor's case here, which is whether or not he is suffering from a mental disease or defect that prevents him from being able to know the difference between right or wrong. So every single thing a prosecutor can show, whether it's something in that book that they could try to divine, but you don't want to get too tricky in front of a jury and stretch out too much of something that you don't need to hear. But training at a gun range is something that they can say goes towards preparation, which specifically the forensic psychologist will say shows that there was an appreciation for knowing what he was doing over a significant period of time, which literally goes to attacking the most important defense that the defense can have here. That's what prosecutors are concentrating on right now. If they start getting into too much about his books and what he reads and what his thoughts are, they're going to throw themselves off track, in my opinion.
The possible defense of not guilty by reason of insanity. So do me a favor and look at this from the defense perspective. What might they be doing at this point in time if they want to present such a defense for Luigi Mangione?
You know, first of all, let me just say that perp walk as a former prosecutor who ran an agency was disgraceful and should not have been done, is going to be the possible undoing of prosecutors. Maybe we could talk about that later in terms of the fact that when they start jumping into the area of the public arena and they're doing things like perp walks and whatever, it's not about the case anymore. It's about egos. And I've seen that literally unravel prosecutions. Also, let's watch out for two jurisdictions that are prosecuting the same individual and whether they're playing well in the sandbox, because when they don't, I've seen that scuttle prosecutions as well. Now, to the exact question that you're asking, the more that they're perp walking him, the more that they're putting him out there bigger, making him bigger, giving him more attention, surrounding him with automatic weapons or semi-automatic weapons and 200 guards and police officers and federal officers, the more they're increasing a likelihood that there could be one juror. This is what gets me nervous as a former homicide prosecutor. Will there be one juror where it doesn't rise to the level of a mental defense, which is very, very difficult for defense to overcome here? In my opinion, they will not overcome it. But will they elate this guy, rise this guy to a level where there's one juror that says, you know what, he is a hero. You know what, he was doing the right thing, and I'm not going to convict him. It's called jury nullification, Julie. And if I were the defense lawyer, I would be working on that jury nullification piece because the evidence is strong. Last point I think is huge. No one's talking about this. How did they get into that knapsack? How did they get that gun? How did they get that notebook? I hope that we don't find out that they should have secured a warrant and they didn't, and they went in there, and down the road the defense is likely to say his Fourth Amendment rights were violated. I've seen this happen over and over again. No one's talking about it, Julie. We are here right now on Court TV because if his rights were violated, that evidence may be thrown out.